Okay, hi everyone. So, welcome to the series of Law of Contracts Basics. So, when we talk about basics, till now we have covered, the fundamentals of contract, what is offer, what is agreement, how an offer and agreement, when it becomes a contract, how offer and acceptance plays a very important role in the formations of an agreement. Then, when an agreement which is enforceable by law can only become the contract. So, these are the basic things which we have discussed. Then we have also discussed that contract can be expressed one, implied one, or there can be quasi contract. Then we have also discussed that there are agreement which is a which cannot be called as a contract also, keeping in mind that agreement can be for certain things which is not enforceable by law. That means you cannot go to the court for getting it enforced, because the legal enforceability factor which is mentioned over here is missing in that such agreement. So only agreement which is enforceable by law will become contract. If any agreement which is not enforceable by law cannot become a contract. Considering that aspect in mind, we can say that agreement is a bigger term, or agreement covers many aspects, and contract can be called as a subset of an agreement or a smaller portion of an agreement. This we have discussed. Then we have also discussed that under contract there's always a need to have an intention to enter into a legal relationship. If there's an arrangement which is based on love, affection, or maybe friendly arrangement, it cannot be called as a contract unless and until, in such scenario also, parties have an intention to enter into a legal relationship. Here intention to enter into a legal relationship basically means that where, in case something wrong happens, you can go to the court, you can ask for your rights. So legally binding obligations are those obligations that a court of law can enforce should one of the parties refuses to follow or refuses to perform their duty. Then we have discussed what is an offer, what is an acceptance. If A is saying to B that I want to sell my car, so A is making an offer to B. If B says I'm ready to purchase your car, so B is accepting that offer. So offer and acceptance we have already discussed. Specific offer if it is being made to a specific person. General offer if it is being made to public at large. This is also we have discussed. Then essentials of requirements of an offer and acceptance, we have covered that how communication of offer and acceptance is essential. Unless and you until you communicate, unless and until you talk about your willingness, unless and until you tell the party that you are ready to perform the contract, it is not going to happen. So you have to basically tell people, you have to inform people that yes, I am ready to accept your offer, I am ready to enter into a contract. So it has to be very clear. Offer acceptance must not be vague also. It shouldn't be like that you have two car, you want to sell X car, the other person is thinking of purchasing Y car. Nay, if you want to sell X car, you have to specifically mention that I want to sell my X car. So this is also which we have discussed in detail. Then we have discussed the invitation to offer wala rule. We have also discussed the concept of postal rule, that is non-instantaneous mode of communication. How does it work? We have also discussed CLAT ka paper. In 2021 CLAT paper, they have asked questions on non-instantaneous and instantaneous mode of communication. Basically they are section 4 of Indian Contract Act, but section is not that relevant. What we need to focus on is the agenda, or what is the idea behind that law, or what they were expecting from us. Then this is two questions we discussed, we solved. Then we discussed what are the essentials of a valid contract, or these five ingredients we took into consideration: that all agreements are contract if they are made by free consent of contract for a lawful consideration with a lawful object, and are not hereby expressly declared to be void, which is mentioned under section 10 of the Indian Contract Act. And all these five ingredients needs to be satisfied if you want to have a valid contract. So the five ingredients are free consent of the parties, lawful consideration, competency, lawful object, and not expressly declared to be void by the court of law. Then we discuss what is consideration. So consideration is something in return of something. For example, if you want to sell your car, so other person will give money. So here you are getting in return money, the other person is getting in return car. So consideration is a promise for promise, or something in return of something. Or maybe in certain cases, let's say if somebody says, I'll paint your house. So the painting part is consideration for you, or maybe the services which is they are providing to you by painting your house. Now you're supposed to pay them back. So this is what is how lawful consideration works. Examples is, says A sells to B 500 bags of grain for rupees 1 lakh. Consideration from A to B is 500 bags of grain. From B to A, it's 1 lakh. Since then the essentials of consideration is being mentioned over here, which says consideration should be legal. It should have some real values in the eyes of law. That means law should recognize it. It shouldn't be like that B asks A to give rupees 50. In return, B would pray to God that A gets a beautiful wife. This cannot be called as a consideration because it is having no validity in the eyes of law. It has to be recognized by law. So if he says, you give me rupees 50, I'll return you rupees 50 after a month, it is a lawful consideration. But saying that I'll pray that you get a beautiful wife is not a lawful consideration. Or if somebody says, you give me 50,000 and I'll pray to God that you get an endless Bangalore, that is also not lawful consideration. It has to have some values. Similarly, adequacy is immaterial. That means if somebody is, let's say, having a car, and a brand new car, jiska value is, let's say, 12 lakh, and after using it for a month, the person didn't like the car. Now he wants to sell off that car, and he is selling it for 12 lakh ki car, which is a brand new car, 1 month bus use hua hai, for 2 lakh. So you may feel like कि how come he is selling the car for 2 lakh. 12 lakh की कार है, कम से कम 10 lakh तो वो मांगे. But here this is a very, very much valid contract because 2 lakh is also having some validity in the eyes of law. It is being recognized in the law. It is having legal backing. So adequacy is immaterial. Whether the consideration is adequate, whether that is not something which will be taken into consideration. What will be taken into consideration is it has some values in the eyes of law. For example, A offers to be a plot of land worth rupees 50 lakh for a consideration of 65 lakh. Agar 50 lakh ki property hai, you can sell it 65 lakh. If you have 50 lakh ki property, if you want to sell it for 50 lakh, you can sell it for 50 lakh. If you want to sell it for 10 lakh also, or 5 lakh also, that is also justified because law is recognizing it. Then there's a concept called as promissory estoppel. This is in a general, you can say, exception to the general rule of consideration. Promissory estoppel basically means that if you have promised something, and basing on your promise, if somebody did their part of job, so now you're supposed to pay. The same example which I gave few minutes back, that if somebody is painting your house, or whitewashing your house, and there you said ki once the whitewash will be done, I'll make the payment. Basing on your promise, the person painted the entire house. Now you cannot say, no, I'll not give you money because you are bound by promissory estoppel. So when a person does something or act at the promise or instant of another, it becomes a valid consideration. Example here says the same. A and B were watching a movie in A's house. A asked B to go get a pizza and that he would pay B for pizza when he gets it. B accordingly goes and gets a pizza. Later A refuses to pay so. So is there a valid consideration? Yes, because एक ने promise किया कि आप pizza मंगवा लो, then I'll give you the money later on. So basing on that promise only somebody ordered pizza na. So here it is a valid consideration and he has to pay the money. Similarly, A wanted to get the community hall repaired. He approaches B in order to arrange fund. B promised that he would contribute rupees 50,000 to the project. A got the hall repaired. When he asked B to give him the promised 50,000, B refused, saying there was no consideration. Again, there was a consideration. It will fall within the exception of promissory estoppel that basing on your promise, somebody constructed the community hall. Na? So now you cannot run away from your promise. You have to pay the money. Then this is where we left in the last class that consensus ad idem has to be there. That means both the parties shall agree in the same sense, in the same manner. If there is, some sort of variation, so it may fall within the definition of counter offer. It may fall within the definition of not accepting the offer. So there, if it is a counter offer, if there is, not acceptance of the order offer, or there is no meeting of mind, then there cannot be called as a contract because free consent is missing or consent is missing. A contract can be bad if the consent is not given freely. Now, if we take into consideration consent not given freely, so it can be influenced by mistake, it can be influenced by coercion, undue influence, misrepresentation, and fraud. Now, you have to understand these things in detail. One thing which you have to keep in mind is in certain types of mistake, let's say where you are mistaken with respect to age of a minor. So there the contract is void ab initio, because a contract with minor is a void ab initio. You cannot have a contract with a minor. It is not a valid contract. So keeping that in mind, it will fall within the definition of void ab initio. Then mistake, where the mistake is with respect to identity, mistake is with respect to subject matter. So there the contract becomes void. Let's say there's a contract between A and B. Now B is no more there, or B is not in a position to perform the contract. So in that particular case, now since the contract cannot be performed, it becomes void. So initially it was very much valid, but because of the change in circumstances, change in the subject matter, now this cannot be performed. So this will fall within the definition of mistake and it will become a void contract. In case of coercion, undue influence, misrepresentation, and fraud, the contract becomes a voidable contract. So what is coercion, undue influence, misrepresentation, and fraud? Coercion is where somebody is threatening you. Basically, somebody is using the tools, or you can say things, to make you do something which is an offense under Indian Penal Code, or which is an offense under Bharatiya Nyaya Sanhita. For example, somebody is aiming a gun on A's head and telling him that if you don't sign the property paper in my name, then I'll kill you. So there's a threat which is being implemented or given in A's, or there's an apprehension, or there's a kind of immediate threat where you are forcing A to sign the contract. If not, then you will kill him. So in that particular case, murder is an offense under IPC and BNS both. So this will fall within the definition of coercion. Or if somebody says, if you don't do this, I'll do this. So there where person is not freely entering into a contract, I'll put your property on fire if you don't name the property in my, if you don't sign the paper in my name. So there also you are threatening the person. And all these are prohibited under criminal law. So under that influence, under that fear, if a person signs a contract, then later on he does have a right to declare it to be a voidable contract. When you say voidable contract, basically you can say that because my consent was not taken freely, I don't want to perform this contract, it becomes voidable. Then undue influence, as the word itself suggests, influence, but in a wrong way. So somebody who is in a position to influence your mind, and accordingly that person trying to utilize their position or trying to take advantage of their position forces you to enter into a contract. Hypothetical situation में हो सकता है doctor a patient, a lawyer and as a client. Uh, let's say, let's hypothetically, let's take my example, me teaching over here. I'm in a position where I can influence you, but if I influence it in a wrong way, then it may fall within the undue influence. I'm not going to do that, but it's just to make you understand that whosoever is in a position to influence your mind, and accordingly that person influenced you or forced you, basically influenced you, and because you trust that person so much, you end up signing a contract with that person. Later on realizes that you never wanted to have this contract, so there also you have an option of declaring the contract to be a voidable contract. Then there's a misrepresentation and fraud. Misrepresentation, which means misstatement of a fact. Fraud, deliberate misstatement of a fact. So there's a difference between misrepresentation and fraud. In case of misrepresentation, your intention is not bad. You genuinely believe something to be true, and that is why you told the same to the other person. For example, suppose there is a bat kept in your showroom, and you know that Virat Kohli never played. Sorry, you believe that Virat Kohli, because there's a signature of Virat Kohli on that particular bat, so you believe that Virat Kohli played with this bat. Now, some customer came to purchase, and they inquired that Virat Kohli ne isse khela hai kya? And you said yes. Here you are not giving a wrong information, or your intention is not to deceive the party. You genuinely believe that Virat Kohli has played with this band, and that is why you told the same to him. Later on, when the customer realized that Virat Kohli ne kabhi is bat se khela hi nahi hai, so this will fall within the definition of misrepresentation, and the contract can be called as a voidable contract if you wish to nullify the contract. Then the next one is fraud. There's a difference between misrepresentation and fraud. In misrepresentation, your intention is not bad. You don't want to deceive the party. But in case of fraud, you know something not to be true, then also you end up saying the same. There, your intention is to deceive the party. Your intention is to make to gain advantage of the situation, even though you know something not to be a true statement. Let's go back to the same example. You know that विराट कोहली ने बस इस पे साइन किया है, विराट कोहली ने कभी इस बैट से खेला ही नहीं है. But when the customer asked for the same, you said yes, 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 this was being used by Virat Kohli, he played with this particular bat. Now the customer will purchase, because customer is having this feeling कि विराट कोहली ने खेला है, so I'll have this bat. He purchased it. Later on, if he gets to know that you were knowing this fact that Virat Kohli never played with this bat, but then also you sold it to him, this will fall within the definition of fraud, and the contract can be declared to be a voidable contract. There's another exception to this, which is like mere silence does not amount to fraud, because you also have certain duty. You are a buyer. There's a concept called buyer be aware. When you are purchasing something, you also need to inquire. Now you didn't like, there's a bat kept in the shop, उस पे सिग्नेचर है विराट कोहली का. आपने पूछा ही नहीं शॉपकीपर से कि विराट कोहली had played with this bat or not. Just because you saw the signature, you purchased it. Later on, you found that Virat Kohli never played with this bat. So you cannot file a case against the shopkeeper, or you cannot say that the contract needs to be declared as voidable, because since you didn't ask from the shopkeeper, he is not bound to disclose it to you, or he does not owe a duty towards you, that Virat Kohli, because he will never get to know na कि आपने ये सोच के लिया कि Virat Kohli was playing with this. So you being a buyer, caveat emptor will come into picture. It's your duty to inquire. If you haven't inquired, so in that case you cannot claim the same. So mere silence does not amount to fraud, but where you have inquired but the other person knows that this is not a true statement, but then also that person continues saying the same, so in that particular case, since the person has deceived you, you can get the contract declared voidable, basing on it was based on fraud. So always keep this thing in mind, that in case of mistake, contract is void. In case of coercion, undue influence, misrepresentation, and fraud, the contract is voidable. The difference between misrepresentation and fraud is, in case of misrepresentation, the intention of party is not bad because he believes something to be true. He has stated there's a misstatement of fact, but intention is not bad. But in case of fraud, the person knows something not to be true, then also the person says the same thing. So there is a bad intention of the person. The intention of party is to deceive you. So there you can get it declared as a voidable contract because it is falling within the definition of fraud. So this is whatever we have discussed from contract perspective. Maybe there will be one more class on contract where we will cover the other remaining aspect of contract, like what is contingency contract, what is wagering agreement, what is the contract of bailment, and similarly some other concepts, maybe contract of indemnity. And then we'll end with the contract part and we'll move ahead with constitution. But before that, I do expect from you guys that you have solved past year paper and you have figured out what all questions have come from the law of contract. So this is all about today's session, guys. See you guys in the next class. Thank you.